jail, even though all the conditions have been met. Your Honor, the state argues on one breath that the bonds need to be consistent, and now they're arguing to this court, well, let's make it consistent with the bond motion that's already at $500,000 where no bond has been set. Your Honor, I still think that the state made the argument that bonds should be consistent, and I agree with them. If that's the argument they're going to have, and that's the argument they're stuck with. They should be consistent the bond was lower. Does it need to be $10,000? Maybe this court will find financial differences in the defendants, but $400,000 remains tantamount to no bond at all. That being said, in the eyes of the law, this defendant sits and remains innocent. So at this point in time, we have an innocent person sitting in jail who does not have the ability to bond out. Now, the state has proffered to this court that there's additional information that the court is not aware about, and the defense counsel is not aware about, and so be it. However, the court is working with the information that it has, and there is nothing in the information that's been brought before this court. There's no way to articulate in any manner that this defendant is in fact a danger to the community. There's no articulation that this defendant is in fact a flight risk. So the only issue is the last argument they had, consistency. And at this point, consistency would demand that this bond be reduced.
Okay, how about the second point?
And what was the second point?
Ability to post bond. You want to present some testimony?
The ability to post bond, the testimony, again, well, Your Honor, at this point in time, I would call the original witness if it doesn't speak for itself, the defendant's still sitting here. But I will call...
No, because this court's position is saying you can't post bond is not legally sufficient to have that argument. The court's position has always been this court's position over the years that the defendant or defendant's family have to actually attempt to post a bond, either by going through the bondsman or having the sufficient collateral, in this case, sufficient collateral or the sufficient cash or so forth to do it. If they've taken no steps to communicate with bondsmen or bonds company or individuals, then the motion is not ripe yet.
Well, Your Honor, again, I did not do a motion I did not exhaust my motion to reduce bond. If the court will note that this actual motion was motion for rehearing on the original motion.
Right, so what's the legal basis for the rehearing so you're just saying now the rehearing on the amount of bond, not the ability to post bond?
That was correct. I didn't file the motion for that. I can actually, if the court would like that, I can bring in the ability to post bond into this hearing. I thought, honestly and candidly speaking, since there was no articulation of this, the state has said that they have proven that this defendant is in fact a risk to the community and danger to the community. I, in good faith and candidly, have no idea how that has been articulated. I don't understand the danger, because the only danger that this defendant could possibly have posed that would be reasonably argued is that if Mr. Lloyd was still on the run, that he could have contact with Mr. Lloyd in his system if that's what, in fact, he was doing. Other than that, this defendant's never committed a crime in his life other than driving without a driver's license once in 2014, and he's not charged with any actual crime himself other than giving someone money. So there's no actual danger besides that. So I don't think that that's been established. As far as risk to flight, I understand the state's argument that he could go to New York and go with family. I think the defense has offset that by saying, no, he's a father of 4 children. He has his family here. He's been in Orlando for 6 years. He's worked at the same job for 6 years. He has ties to his community. So I think that that's where the defense challenges that. As far as fleeing the country, we've turned in the passport. So the only thing left was we just have a $400,000 bond because the other bonds are so high. There's no particular reason for $400,000 bond other than the state's argument of consistency. And at this point in time, since that has changed, and not because another judge randomly put an amount, but the state actually made a decision to drop it down to $10,000, at this point in time, we have an innocent man sitting in jail, and I don't say innocent because it's an argument, it's innocent because it's a fact in law, and he can't post bond.
Well, I don't know that yet. You haven't. That's right. You're putting both of them together. Motion for reconsideration is the amount of bond. It's different than whether or not the person can post a bond, and posting the bond is not definitive. And the state was correct in the cases that they provided at the original bond hearing that tantamount to no bond is not really the standard.
Oh. What the state presented to this court, and specifically, I mean, again, for the reminder of the court and for the benefit of the record, the state presented in this case, it was 143 Southern 3rd 432, and that was the case that they presented in this case. And that's just for the principle that a monetary amount doesn't just go to the financial ability. It says you could take into account danger to the community and risk of flight. And in this specific case, again, and I'm wholeheartedly arguing this in good faith and candidly, and if the state feels otherwise, they can articulate it for me now. I did not hear any part that makes him a danger to this community. I can't put a sentence together that would make him a danger to this community. Nothing.
I can do that.
Go ahead.
Deborah Clayton is dead because this man helped Markeith Lloyd stay out after Sade Dixon was murdered by Markeith Lloyd.
One, the defense contests that and says that didn't happen. And two, if in fact the state eventually does prove that and this defendant is found guilty, we can totally punish him for that. And the court will enter a sentence accordingly. But at this point, the defendant pleads not guilty and remains innocent. So if there's an actual articulable threat for letting him out, not just punishing for actions that happened in the past, then the court should consider that. But that is not a threat to the community. That is something that he's accused of doing that in and of himself, he also didn't take action. He's not accused of actually shooting anyone, actually harming anyone. And the threat that could be is he would continue to help Mr. Lloyd, who is an accused murderer, and that would be dangerous to this community. But Mr. Lloyd's now behind bars. So again, that's the argument. Your Honor, if the court would be so kind as to give me one moment, I believe if the witness who actually is currently present might be able to address the other issue.
Sure.
Thank you.
That other issue wasn't set for a bond hearing, though, today, as the court has already pointed out.
Well, at the end of the day, first of all, if I rule and stay the bond where it's at, then we'd be back again for that issue.
Yes.
If the state wants to do it piecemeal, then that's the state's right because the parties have to be given that. And even if I lower the bond, whatever I lower it to, the issue will pop up again, and the state would need to be noticed for that as well. So
That would be the state's preference, Judge.
okay. So anything else, Mr. Mason?
Fair enough. Since we're not going to move forward with that portion of this, again, the purpose of this rehearing is the change of the two things that I think should, again, be considered by this court was, again, because I believe, since it was argued and taken in good faith, was the consistency of the bonds. As the court noted in one of the defendant's case, Ms. Slaughter's, there's been no bond motion filed. So there's no consistency to argue there. In the other case, Ms. Smith-Lloyd's, there was a bond motion filed. That bond was reduced to $10,000. Both are similarly situated that no information has been filed at this time. The only thing that's differently situated now is this defendant is sitting in jail.
Okay.
Thank you.
Ms. Hicks, anything else?
No.
Anything else? Mr. Mason, you get the last word. Anything else?
Your Honor, no. Again, I think what was written in the motion speaks for itself, and I'd ask that the court consider both what was spoken here today and what was written in the motion, and both Exhibit A and Exhibit B. Thank you.
All right. Motion for reconsideration of the bond is denied. Have a good day.
Thank you, Your Honor.
Thank you. I have one more case. Darren Threats. Mr. Threats, you ready?
Yes, Judge.
Good morning, Mr. Chop.